understand why you do it, because, for example, when I read Countrywide, I think of Justice Peregrine.
Yeah,
Right? I mean, that's just how we do it. And I remember some of the Maupin decisions. I mean, I just think about it that way.
no, I mean, as long as we're not on the record, I try to forget the Maupin decision. This is the unique
This is
exposure.
being televised, okay.
All right, I just want to say good morning to everyone and welcome you to the March 15th, 9:00 a.m. law in motion calendar. We only have one matter on. Of course, that's Gallagher et al. Versus Affinity Lifestyles et al. Let's go ahead and set forth our appearances. We'll start first with the plaintiffs, and then we'll move to the defense.
Your Honor, Will Kemp for plaintiffs.
Good morning, Your Honor. Abe Smith, Dan Polsenberg, and Elizabeth Lowell for Milwaukee.
Good morning, Your Honor. Ramez Ghally for Hanna Instruments.
All right.
And this is Daniel Jocelyn on Zoom for defendants Real Water and AffinityLifestyles.com.
Okay. All right, and so we should finish this morning, right?
So we should finish in the first half of the morning.
Yeah, the only reason I bring that up, my afternoon, I have a trial starting Monday. And so they're coming in for, I guess, some final tweaking pre-trial regarding pre-instructions and those types of.
Mr. Bredsky, Your Honor.
Yes.
Well, then maybe we'll go all day.
All right, so I guess what's next up?
We only have the motions to alter and amend
Okay,
by the defendants having to do with interest and offset.
and would that be Hanna Instruments motion to alter and or amend?
They have one, and we have 1297 for Milwaukee.
Yeah, so we're talking about 1291 and 1290. Is it 1297 or
I believe so. Let me double check.
1298?
Yep, you're right. I was looking at the 50B motion and the 59A motion. Thank you, Ron. So the issues
So
that
for
are
the record,
presented,
though, 1291, right? That's what we're going to first.
1298.
Okay, 1290. Just want to make sure I'm with you. Go ahead, Mr. Posenberg.
Thank you very much, Your Honor. So the two issues here are interest and offset. Let me do interest first. Though I could do either one. So it's clear Nevada law that if to make a prima facie case to get prejudgment interest, plaintiff must prove that part of their claim and which part of their claim is for past damages. Boy, that's been around forever. Everybody knows that. And the most recent case is from yesterday, and it's Valley Health System versus Murray. And there the court said, Nevada law is clear. Prejudgment interest cannot be awarded on future damages. It cites the statute 130, and it cites Albios, the 2006 case. But there are a ton of cases on this, and cases that make absolutely clear it is plaintiff's burden to show what part of their case is past damages and what part of their case isn't. Are there exceptions? The only exception is if the entire case is past damages. Now, they rely on Bongiovi versus Sullivan and say this case is like Bongiovi versus Sullivan because there the jury was told about past damages and future damages, but the court concluded it was only past damages. Well, this case is way different from Bongiovi versus Sullivan. And Bongiovi versus Sullivan, remember that was the defamation case between Dr. Sullivan and Dr. Bongiovi. The two of them could not get along, famously. And there, the damages were for defamation, and it was just past damages. It wasn't a case that went to the jury on both. Plaintiffs here tried to say, oh yeah, but using the arguments that Dr. Bongiovi used on appeal to say that, yeah, they were combined past and future. And I'm fairly familiar with those arguments. And The arguments there were not very good, because all it was is that Don Campbell in closing argument said, man, that's the kind of remark, talking about Dr. Sullivan's reaction to what Dr. Bongiovi had said. That's the kind of thing you'll remember the rest of your life. And there was a jury instruction that happened to mention the effects in the past and the future, but the jury was not instructed there were past and future damages. They were not asked in the verdict form. Here in the verdict form, they were instructed on past and future damages in questions 6, 7, 8, 9, 10, 11, 12, 13, 15, 16, and 17. Not 14, because 14 dealt only with the decedent's pain and suffering, which clearly would be only past. In fact, that this is like the case from yesterday, the Murray case, where the Supreme Court said the jury here awarded a combination of past and future damages. It awarded past damages for the decedent's pain and suffering and funeral expenses. Damages for loss of consortium were reflected future damages. There was an element of future damages in this. And the court said the grief and sorrow damages in the verdict form for the heirs explicitly commingled, quote, past and future grief and sorrow. So there the verdict form said past and future, like it did here. This is not a case like Bongiovi versus Sullivan. So the Supreme Court said, in very clear language, Your Honor, the district court ordered prejudgment interest on the aggregate amount of compensatory damages and plainly erred in doing so. Accordingly, we vacate the award of prejudgment interest. Plaintiffs here argue that that we waived this issue by not objecting to the jury verdict. Well, no, we didn't. It's their burden to put forth the correct verdict. But look what the Supreme Court said in Murray. It's plain error. The court said that the plaintiffs in Murray, or excuse me, the plaintiffs in Murray, yes, had argued that defendants had waived the issue by not bringing it up. And the Supreme Court said, no, that they are addressing it for plain error. Could be more plain than this issue that we all know you have to have in the verdict form. You knew it as a practicing lawyer, Judge Williams. I can't, but I have argued jury instructions and verdict forms with Mr. Kemp quite a number of times. He knows it. Teddy is one of the best trial lawyers. Oh, wait. Teddy's here. Teddy is a competent trial lawyer.
I did hear that.
Well, don't order the transcript, Teddy. Abe, in Rules Committee meetings, Abe always has to say, Dan, you're dictating into your phone while you're got your mic on. So everybody knows this. This is plain error. The court needs to object. Now, I'm going to tell you.
I don't object. I mean, you tell me how to rule, but you're saying which court needs to object.
No, I'm not saying you. Well, actually, you know, there was a discussion, if you remember, in the DeJesus versus Flick case, the now discredited DeJesus versus Flick case, what a court needs to do. But to make a prima facie case for plaintiffs, they need to propose a jury instruction that splits it as the past and future. Otherwise, they're not entitled to it. And therefore, I think they waived. Murray goes a little further. As I recall the facts of Murray, it was actually that plaintiffs had proposed a verdict form that had past and future. Defendants insisted on one that combined it. And even under those circumstances, the Supreme Court has said that defendants didn't waive it. So we didn't waive it here. We didn't have an obligation to raise it. Now there's a funky thing in the Murray case. in that case, the Supreme Court said, since the court was vacating the award of non-economic damages and requiring the district court to recalculate it, the district court could on remand determine what portion of non-economic damages was attributable to the decedent's pain and suffering and allocate prejudgment interest to that. You don't need to do that kind of recalculation because the jury awarded an amount for that specifically. But as to the other, you're not in a position to recalculate. The district court in Murray conceivably might be in the future in a position to have to do that because it has to recalculate damages. You're not recalculating damages here because you didn't grant the motion for new trial. Granting the motion for new trial might bring the damages issue back in front of you, but I think it would deny our right to a jury trial to allow you to calculate them here. And I don't think you'd be able to do that. So there was issue. I mean, this is the easiest case, Judge. It's in the verdict form saying past and future. We've set out in our reply the evidence of future damages, but we heard it the other day from Mr. Kemp. When Mr. Kemp got up here trying to make an argument, and a successful argument, that there weren't excessive damages because when compared to the specials, because he says, well, some of these cases there could be amputations in the future, and that would have different special damages that could be reflected in pain and suffering and mental state. So they are even admitting in arguments in these post-trial motions that there is evidence of future damage. This is not like Bongiovi versus Sullivan, where there was no evidence, where the remark from the judge in an instruction was a stray line 3/4 of the way through a jury instruction. This actually went to the jury on past and future damages, and under Murray, I think the award for prejudgment interest on most of these categories has to be vacated, just the way the Supreme Court did. Let me take up offset. This is highly theoretical. So plaintiffs are coming in here saying that they'll admit that there is an offset for the settlements, the prior settlements of other defendants, which is very nice of them to do, since I actually argued that issue against Mr. Kemp in the motor coach case. And the Supreme Court said there is an offset, but their theory now is, oh, but it's only a partial offset because some of the settlements could have been for punitive damages, an aspect of punitive damages under the case I call J.E. Johns and he calls Lindbergh. And that's just too hypothetical. That's too many unanswered questions here. What portion is for punitive damages? We don't know. They're coming in the second motor coach appeal. They argued that it should be a 3-to-1 ratio on the offset. They lost in the district court on that. They appealed. Now they're arguing what, a 9-to-10 ratio? How are you ever going to figure that out, Judge? How is any district judge going to figure it out? Is any of this settlement for punitive damages? What aspect of it is for punitive damages? This is too far-fetched. And it's not a question, you raised that when we argued this before, it's not a question of you determining whether it's excessive. They're asking you to determine something that isn't determined what percentage is for punitive damages. Now, look, I don't think any of it is. And just because studies show that punitive damages are awarded less in products cases and medical malpractice cases than any other cases, they can't show they would have gotten punitive damages in this case. You and I both worked with Neil Gallitz. Neil used to say to me, plead the loosest form of burden that you need to prove, but prove the most that you can. What's your point about that, Dan? My point is, plaintiffs' lawyers don't settle with the most culpable defendants and claim that they would have gotten punitive damages. They would try those cases and get punitive damages. So we can't go on the assumption they would have gotten punitive damages here. And what's the ratio? They come up with, I think they're striving for the 9-to-1 ratio hinted in the US Supreme Court cases that we talked about, including
State Farm,
Campbell.
is that State Farm?
State Farm versus Campbell, the case out of Utah, where there's a suggestion that a ratio of more than 1 digit would be suspect. Well, there are cases in Nevada where there's a ratio of 1-to-1. Look at Bon Jovi versus Sullivan, where the arguments were that the damages were excessive and the punitive damages were excessive. It was $250,000 in compensatory, $250,000 in punitives. 1-to-1 ratios are not uncommon, especially depending on the type of case. Are they going to prove to you that they would have shown malice by clear and convincing evidence to a jury? All hypothetical. This is too much for a court to handle. Now, when they go into, they use the word exposure. Justice Hardesty uses the word exposure 5 times in J.E. Johns. And I've argued this to you the other day. Exposure to me means exposure. And exposure to what? You look at most of the cases in Nevada where the word exposure is used, it's exposure to something. It's exposure to the elements. It's exposure to a condition. I think they were on the verge of convincing you that exposure means risk, but no, that would have said exposure to risk. Treble damages is exposure. If you are liable for certain kinds of damages under certain causes of action, you are automatically liable for treble damages. That's exposure to treble damages. We don't have automatic punitive damages in Nevada. The closest we have is under NRS 42.010. Careful, anybody researching, that used to be the number for the punitive damage statute. Now it's the number for the DUI punitive damages, where none of the protections of the rest of Chapter 42 apply. You don't need clear and convincing evidence. You're not restricted to 3-to-1. It's as close to automatic as you can get. It doesn't apply here. They're not in a situation where there's an automatic exposure to punitive damages. Well, Justice Hardesty used the word exposure 5 times. It's used 29 times in the Texas Mobil Oil case that he cites in that Supreme Court opinion. But in those 29 times, they're talking about exposure to benzene. Exposure is not just a risk, possibility. If there could have been punitive damages, we're going to reduce the offset. That's just too far. Texas does allow you to have, for the judge to determine what the offset, what amount of the prior settlement would have been for punitive damages. How did they do that? They do that by looking at the settlement agreement. To make a prima facie case of a reduced offset, a plaintiff has to present the settlement agreement. They failed to do that. They've waived this issue. And why do we require the settlement agreement? Because the 2 parties in the settlement would have had to have, at least to make a prima facie case, agreed to the allocation to compensatory and punitive damages. And as I mentioned before, there is risk to plaintiff in that, because if they attribute a percentage of the settlement to punitives, they have to pay taxes on it. So there's a reason why they wouldn't want to do it. I'm still trying to figure out whether defendants would be allowed to deduct an allocation of a settlement that goes to punitive damages. But at least plaintiffs, I mean, simply put, to make a prima facie case, then you'd still have to look at all the arguments about whether it's an appropriate one. To make a prima facie case, they would have to show a settlement agreement where they allocated a percentage of this to punitives.
Here's my question in that regard, because we know when it comes to insurance companies, they have two primary duties, and we know that. Duty to defend, duty to indemnify. But I haven't seen many, if any, insurance policies that pay for punitive damages when it comes to settlements.
It is rare, and it's very rare in our ordinary practice.
You see where I'm going on that? I mean,
Yes,
it's rare.
absolutely.
You notice I didn't say it never happens, because I'm quite sure that when it comes to making money and underwriting, insurance companies can have special policies for special individuals. But my question is just coming back to the general, I guess, commercial type insurance policies as it pertains to indemnity.
Right.
Typically, they don't pay for punitive damage.
Exactly right. Exactly right. And thank
So-
you for pointing that out.
But here's my point, though. You're saying, look, it's their responsibility pursuant to the terms and conditions of the settlement to bring forth the settlement agreement. I just want to make sure I understand what you're saying.
Yeah,
And show some sort of allocation
yeah.
between compensatory and punitives. But my point is this: insurance companies don't pay for punitive.
No, they're not going to pay for it. Exactly right.
Okay.
So they would not be in a situation where they would say, yes, we're paying half for punitives, because it usually is not covered, almost, and in a case like this, almost always not covered.
Okay. And so my question is this, though, when it comes to offset, would it be inappropriate for me to come to this conclusion that any settlements couldn't be offset vis-a-vis punitive damages?
I think you have to do an offset on for the entire amount of the settlement. Yes. And let me point out one more thing.
And I want to make sure I'm clear. You say offset for the entire amount of the settlement. I kind of get whatever's been paid gets offset. It would probably offset the compensatory, not the punities.
It would, well, there are no punitive damages against Milwaukee.
Okay. I got
So I'm saying I get an offset for that entire amount as to.
I understand. I did. I got it. I was kind of
Let me add
conflating some of the other.
that is a very interesting point, whether you can have an offset for punitives. I would, while part of me would love to have that discussion, the greater part of me is very happy I'm not in a situation where I have to.
I get that 100%.
Let me raise one last point. Where's the case that says a plaintiff has to have the prima facie case? It's a Texas case. It's Mobil Oil. It's the case that Justice Hardesty cites in the J.E. Johns opinion. Thank you, Your Honor.
Thank you.
Your Honor, just for the record, Hanna does join in the arguments made by Milwaukee regarding both the offset and the prejudgment interest. And really, there's only one Hanna specific argument related to the prejudgment interest that I want to make separately. So I don't know if we want me to do that first and then have Mr. Kemp go.
You might as well bring it up now.
Okay.
Bring it up now.
Okay.
That makes it easy.
So our argument, the Hanna specific argument, really focuses on this other section of NRS 17.1302.
But wait. I want to follow you. So I have the statute out in front of me, 17.130, paragraph 2.
Correct, Your Honor.
All right.
Which says a judgment draws interest from the service of the summons and complaint until satisfied. That's the section we're focusing on here. So here, Your Honor.
That would be after the comma in the second sentence. And I just want to make sure I'm following.
Correct, Your Honor. Yes.
The judgment draws interest from the time of service of the summons and complaint until satisfied.
Correct, Your Honor.
Okay, I'm with you.
Okay, so based on that section, Your Honor, Hanna maintains that any prejudgment interest against Hanna must account for the time when Hanna was served with service and process. And I think the statute makes that very clear. Service is inherently a defendant-specific timing. You know, the legislature could have picked when the injury occurred. That's a plaintiff specific timing. They could have picked the time the complaint was filed. That's a fixed time. It didn't. It picked at the time of the service of the summons and the complaint. And you know, the intent behind that is clear. A plaintiff shouldn't be able to run up the score against a defendant who isn't even involved in the case and could defend themselves. So here, Your Honor, given that Hanna wasn't served until 2 years after this case was first initiated, any prejudgment interest awarded against
When
Hanna.
you say that, what date? Just give me a date, because I'm taking notes.
Sure, it is October 21st, 2022. That's when Hanna accepted service.
And that was service on Hanna.
Correct. Your Honor. So from that date forward is the applicable date for calculating any prejudgment interest against Hanna here, Your Honor, under the statute. Unless you have any questions, Your Honor, that's it.
Thank you, sir. I don't have any. I understand your position. All right, Mr. Kemp.
Your Honor, addressing it in the order that Mr. Polsenberg directed, starting with the prejudgment interest. You know, we heard a lot of argument. We didn't hear any specifics as to what damages item he was complaining about. And the reason for that is because there was no evidence presented of future damages. None whatsoever. If the court recalls, there was a stipulation, one as to the amount of the medical bills.
Vast medical.
Vast medical bills, and two, on future medical monitoring, there was a stipulation. I can't remember what it was off the top of my head. I think it was about 50,000 for plaintiff. That would be the future damages, and we did not include that in the prejudgment interest calculation. So what he's arguing is that there was some damage element that there was no evidence presented on, that the court has to allocate or just throw the whole thing out. And what is it? I don't know, because again, this was an acute liver failure case. So the evidence of the injury to the clients were Dr. Hudson testified that they all had permanent liver injury. That's a past damage. They had that before they filed the complaint. So prejudgment interest would be appropriate on that. He did not argue what I call progression. In other words, he didn't argue that they have fibrosis now and it's going to progress to cirrhosis and that they're going to have liver transplants. He didn't testify to that as to any of the plaintiffs. So there was no evidence of progression submitted. Mr. Polsenberg said something about evidence of amputation being submitted. Not in the Gallagher trial, there wasn't. There was no evidence submitted that the plaintiffs in that case, Haley, Belsky, and the like, were going to have amputations. That would be a future damages if there was evidence presented of that. There was no evidence presented of that. The only evidence presented was that they had a permanent liver injury. Okay, and then there was no argument of future damages. And the reason there was no argument of future damages is because we had the medical monitoring stipulated it too. So we did not take prejudgment interest on the medical monitoring. The other big ticket item is the $500,000 for loss of companionship. We think maybe this is a little bit of a gray area, but we decided to concede that. So we are not taking prejudgment interest on that item either. And that would be $500,000 to each one of the three Ryerson heirs. So Mr. Polsenberg says over and over again that plaintiffs must prove that none of the verdicts was for that it was all past damages, none of it was future. That's not what Bon Jovi said. Bon Jovi said that the defendant, if it was going to contend that part of it was for future, has to submit a verdict form. If it doesn't do that, it waives to it. And the Supreme Court specifically says nothing in the record shows that the jury otherwise received evidence of future damages. Well, where's that here? What has Mr. Polsenberg cited to show that there was an argument made as to a specific future damage? And again, How could there be? Because medical monitoring was stipulated to, and progression wasn't argued, past injury was argued. So for those reasons, we think Bon Jovi applies squarely to the issue at hand. Counsel's point on service, I think he's probably right. I think the prejudgment interest should run back to the date that they were served. I don't know if that was done in our original calculations.
And that's statutory. That's
Right,
written
that's
statute.
statutory.
Doesn't
So-
use, they don't need any interpretation. It says what it says. But that's why I wanted to make sure it was clear on the record as to what exactly you were relying upon.
Now, moving to the punitive damages, moving to the offset. This, we have a new case right on point. It's J.E. Johns versus Lindbergh. I like calling it Lindbergh. Mr. Polsenberg likes to call it J. Johns. So let's just call it Justice Hardesty's recent decision on offsets. So that case says that if it's the same injury, you get an offset. We have conceded that it is indeed the same injury. All right, so they do get an offset. Now, Justice Hardesty in the Supreme Court went into a lot of detail about the reason we give offsets. The reason, the policy underlying of the offset analysis is you don't want to give someone a double to cut.
I mean, that's just basic. I don't know why you gotta go into great detail on that, but you don't want double
Well,
recovery.
it's two things, and then they don't want to reward the defendant.
Right.
Like, for example, we're talking about the monies paid by UNFI primarily here. So we didn't have to sue UNFI. I mean, if we hadn't sued UNFI and gotten a recovery from them, we wouldn't be making this argument. So in a way, it's a complete windfall in my view, but that's not the way the court looked at it. The court said you have to look at, and the test is exposure. The test is not adjudication. And the reason the test is exposure is we're trying to promote settlement. We're not trying to make you adjudicate every case to determine what the amount of the offset or the set off should be. So Judge Hardesty does use the term exposure. In that case, they held that the person, the defendant in the case was exposed, the settling defendant was exposed potentially to treble damages under a real estate statute. And because of that, they allocated part of the damages to actual damages, I'll call them, and part of the settlement to actual damages and part of it to the 3-to-1. And so basically what they did in that case is, I can't remember the amount paid, but let's assume it was $100,000. So they said $100,000, we're gonna give you a credit on a 3-to-1 basis for $25,000 to the actual, and then the other 3 goes to 75 goes to the theoretic trebling. And there's no claim for theoretic trebling against the defendant whose judgment was rendered against. So they don't get an offset for that. So you apply the same test here. The exposure test. Was there exposure to UNFW? Of course there was exposure to UNFW. The court denied a motion for summary judgment on punitive damages right before trial. So you can't say there's not exposure. So the issue becomes, how do you allocate between UNFW on compensatory and punitive? That's the issue. Mr. Polsenberg says we should look at the settlement agreement. That is not the test adopted in J.E. Johns versus Lindbergh. Okay, that is Texas law, and he kept referring to the Texas case of Mobil Oil. That's what they do in Texas, Your Honor. That's not what they do here. That's not what Justice Hardesty did. He cited that proposition for that case for another proposition, but he didn't cite it for the proposition that we should look at the settlement agreement. Okay, and I think there's a good reason for that, because if you look at settlement agreements, you create the incentive that plaintiffs and defense counsel will be collusive. They'll try to manipulate the credit, and
And that's not what happens.
that's not what happened. But so is there an exposure in this case? to
Because I mean,
punitives?
when you look at it from a practical perspective, when you settle a case from a defendant insurance company perspective, you're more concerned about, as the defense lawyer, protecting your client.
That's right. And
Nothing more, nothing less, protecting your client. And I
think
did
the
defend for it.
fact that the settlement came days after the court denied the motion for summary judgment on punitives speaks volumes as to whether or not there was exposure to punitives. If the court had granted that motion, I wouldn't be up here making this argument, because I couldn't argue that there was exposure. So the issue becomes how we're going to allocate it in a case where we have punitive damages. Now, the case Justice Hardesty had in front of him, again, the real estate case, he had statutory exposure 3-to-1. Okay, Mr. Polsenberg calls it automatic. I don't know if it was so automatic, but it was 3-to-1 exposure under that statute. So in this case, we have to look at what should we allocate to the compensatory in UNF and what should we allocate to the punitive? So Justice Hardesty, and there should be no doubt that this allocation test in J. Johns versus Lindbergh applies to punitives because Justice Hardesty used the term punitive 5 times in there. And, you know, Mr. Polsenberg convinced Judge Escobar that that was mere dicta, and this J. Johns test doesn't apply to punitives. And that's the issue going up on the motor coach case right now. It's not mere dicta. Justice Hardesty is not the kind of guy who's going to use that 3 times in an opinion and have it be dicta. But look at the policy rationale. You're trying to allocate it to avoid giving a windfall to the defendant or a double recovery to the plaintiff. So you've got to allocate it if there's a unique exposure. In this case, there was a unique exposure to UNFW because, as I said already, you denied the motion for summary judgment on punitives, and there's no such exposure in the verdict as to Milwaukee because they won the punitive claim. So what they want to do is they want to take some of the exposure, some of the allocation that UNFW had, and they want to take that credit, and then they want to apply it to the compensatory claim. That's really what they want to do. They want to reduce their liability for compensatory. So the real issue, I think, here is whether you just take a 3-to-1 ratio, which is a ratio that if Mr. Polsenberg was arguing for that, I think, you know, there'd be some rationale for it. Or you want to take the actual adjudicated ratio in this case. In this case, we went to verdict against Real Water. We had an adjudicated ratio of punitives vis-a-vis compensatory. True, this was Real Water. This wasn't UNFW, but that's the best we have. So Real Water, the manufacturer, UNFW distributor, we have an adjudicated compensatory punitive ratio, and that's the ratio we submit should be applied, 89% to 11. And Your Honor, if Mr. Polsenberg stood up and said, look, let's just put this to bed, I'll agree to 3-to-1. If you would, I would probably agree with it just to put the issue to bed, Your Honor. But
Your Honor, I'll agree with 0-to-1.
well, okay, well, we got an agreement.
Here's another consideration. I mean, I don't know, and I have to take a really close look at the case. And there's an issue raised as it pertains to treble damages. And there's policy reasons for a lot of different types of categories of damages, like in elder exploitation cases, there's double damages as a matter of law, right? But here's my question, and then we have in a lot of different areas treble damages, and there's policy reasons for that. And then we run to 42.001, fraud, oppression, or malice, or conscious disregard, which you don't have to have an intent to harm under countrywide under footnote 55. And so my point is this: do I even because they talked about treble damages, but potentially statutorily treble damages could be there for a much different reason than punitive damages.
Exactly right. I think 3-to-1 would be the lowest you would go on an allocation that involves punitive damages ever, unless you add something. You know, punitive damages, Mr. Polsenberg.
And you know, does everybody understand where I'm going? Because I'm looking at it from to me, it depends on certain categories and so on, and what the purpose of it, the statute might be, because they did talk about treble damages. I'm gonna take a deep dive as far as that case is concerned, but I'm gonna take a look at the treble damage statute also.
Yeah, it's a fascinating case, Your Honor, J. Johns versus Lincoln.
Yeah.
And you know, on the point that there's an argument made in the briefs that public policy forbids insuring against punitive damages. I would argue exactly the contra, and actually we've been looking for a case to bring this up to the Supreme Court for a couple of years, haven't found it yet. If you recall, in our Constitution, people have the right to contract. That is a constitutional right. You have a constitutional right to contract. So their argument is that's somehow superseded because it's punitive damages, that a sophisticated client like MGM can't go to Lloyd's of London and enter into a contract to spread their risk on punitive damages. That's what this whole argument boils down to. So my argument is that if an insurance company wants to, it can contract to pay for punitive damages.
Well, I kind of brought that up at the very
Right.
beginning.
Yeah,
It's
you brought
very
that up at the very
rare,
beginning.
but yeah.
But in this case, you know, we know a little bit about the real water insurance situation, as we point out in one of the other briefs. There's actually a debt relief action going on right now as to whether or not that covers punitive damages. So at least the insurance company is alleging that Real Water is claiming that their policy covers punitive damages. We haven't boiled down that point to the UNFW policies yet. They haven't, you know, they've got the policy just like I do. They haven't argued, they don't cover punitive damages. They were all produced in discovery. But I don't think that's the kind of test that Judge Hardesty is adopting. He is adopting a mere exposure test. He's not trying to say, okay, what did they have in the settlement agreement? What's the insurance policy say? Let's go adjudicate the case against UNFW so we can figure out the offset. He's not saying that. He's got a bright line test in this Lindbergh case. And I think that makes a lot of sense because you got to remember, we're still encouraging settlement. We're figuring the offset for, this is an equitable determination. So we're figuring out for an equitable determination. We don't need to go have jury trials against theoretic settling defendants to determine ratio. So I think that's why we use the one we have here, or we use the 3-to-1. But Your Honor, I would just ask the court to take a close look at the Lindbergh case, and I think you'll see exactly where I'm going with this.
Thank you, sir. Mr. Polsenberg.
Thank you, Your Honor. I don't think you can say, no disrespect to anybody, that there's a recent case written by Justice Hardesty. I think you could say that the case I cited from yesterday, written by Justice Stiglitz, is recent. But, you know, the counsel keeps bringing in the ghost of Justice Hardesty as if this decides everything. I get accused of being nonlinear. I was having trouble tracking that argument. Let me go to your point first. Can there be insurance coverage for punitive damages? Yeah. Counsel brings up the insurance in the MGM fire case. I remember that. That was even retroactive punitive damages insurance. Lots of public policy issues there, all raised before Mr. Smith was born. Are there policies of that cover punitives? Yeah, I was in a case recently in front of Judge Bluth where it turned out we had 11 insurance policies, eight of which covered punitives. That was an unusual situation.
And I agree, it's unusual, but there's not a blanket prohibition against it because.
And I'm not arguing there should be. I represent an insured here. I am certainly not going to argue there can never be insurance coverage for anything. But the fact of the matter is, in the ordinary situation, settling a case, an insurance company is not going to make part of the payment allocated for punitive damages. Counsel brings up Real Water's insurance. Who cares about Real Water's insurance? They're not one of the settling defendants that right now that I'm arguing for an offset for. Counsel argues like there's some mythical minimum of 3 times compensatories for punitives by statute. And by case law, juries do not have to give punitive damages, even if they find malice. And we even have 2 phases. In the first one, they decide whether, not just did you find malice, now you award punitive, whether they determine that they will assess punitive damages. There's no automatic punitive damages. And if you want, I can do supplemental.
And that's why I actually brought up, you know, there's so many differences in the types of whether treble damages, what would be the purpose of it from a policy perspective, double damages for elder abuse and all those things. And it's funny about the elder abuse, I haven't looked at a statute in a long time, but it's my recollection. This is automatic. This double whatever they took, something like that.
Yeah, and it is.
Yeah.
And that's why I pointed to you when you brought up that example. That's my favorite example. You know, I've got some published opinions in healthcare facility cases. Giving credit where credit is due, Mr. Smith always argues those. But there we often sued for elder abuse issues where the double damages are automatic. The treble damages in J.E. Johns were automatic. That's why I use the word automatic. And you get into punitives, and how are you going to decide when there isn't such an automatic thing? I argued about Bongiovi versus Sullivan, where it was 1-to-1. It was 1-to-1.
That's Mr. Parker's case. I know he probably wanted to comment on it, but that was Mr. Parker's case, right?
I am looking forward to at least throwing a few tidbits in after Mr. Polsenberg gets finished.
You don't get a server reply.
That's Mr. Parker.
I argued Bongiovi versus Sullivan.
I know.
I didn't write the briefs. It was not a good argument that there were future damages in Bongiovi versus Sullivan. It was just Dr. Bongiovi making some pretty rude remarks about Dr. Sullivan. So that was not a. Teddy's going to go look up.
And that was when Las Vegas was such a smaller community back in the 80s, and everyone knew everyone, and everybody knew Dr. Bongiovi, and so, that's just
Or
kind
at
of,
least his son.
or at least the son, and it was a much smaller community.
Right, but you can't say what a jury would have done in a particular case that never went to a jury. You can't say it would have been 10-to-1 or 3-to-1 or 1-to-1. We just filed a brief recently in the United Healthcare case where we talk about all the cases where the Supreme Court has said, no, it's got to be a 1-to-1 in that kind of situation. Now, I'm not saying this falls into that, but there's a huge spectrum that includes, and I was not being entirely facetious, 0-to-1. The jury doesn't have to give punitive damages at all. This wasn't, counsel says, theoretical trebling. It wasn't theoretical trebling. For the cause of action in J.E. Johns, there was automatic treble damages.
What do I do about the one situation that was raised by Mr. Kemp, and he talked about future damages? And he said, look, Judge, the only evidence of future damages we had in this case would be medical monitoring.
Well,
and the reason why I bring that up, because normally what happens, and we all know how tort cases work. And this wasn't a scenario where you had life care plans and all these things as it relates to future injuries and future necessities from a medical treatment perspective, and so on and so on. What do I do with that?
as long as there's a component in the damages of future damages, they do not get prejudgment interest. Was there a component? We did pages in our reply brief on this. We talked about Dr. Costa.
I'll bottom line it for you. You said, Judge, you're saying, look, it doesn't matter as long as it's a component. It doesn't have to be a major factor, just as long as, okay, I understand.
Right. And here, Teddy, during rebuttal argument in the trial said, you have 6 people here with acute liver failure looking down the barrel of buying tests for the rest of their lives. That's future. Eric Pepperman said, the seriousness of what they've gone through and what they will continue to go through, living every day for the rest of their life, wondering if this terrible disease is going to come back. When is it going to be worse? Is it going to be to the end of time?
And I just have a question for you, and I don't know for sure because I can't. Unfortunately, we have a lot of cases go to trial, but what was the status of the medical evidence as it relates to that? I understand what the arguments might have been. Just what did the doc say? Because it was my recollection from a medical causation perspective, the physicians focused on the necessity or need for future medical care. And based upon the types of injuries they had, they said at best it would be medical monitoring, something to that effect. Because I always have to, lawyers argue a lot, and if it's not objected to, it's there in the record. But my point is this: what did the docs say?
Well, Dr. Hudson talked about scarring and the.
Oh yeah, that was talked about. But the thing about scarring, and we know this about scarring, you can have scarring without any. I guess it depends on the degree.
But you can have, and there was evidence that 66% would have scarring in the future. Camille Gallagher said that she was worried about the scarring, because that's what really worries me. What is the future? But here I don't. Right, so we're talking about the emotion, not just what is going to be the future. And Will makes that argument that the only element of special damages had to do with medical monitoring. But what we are not talking about is just special damages. We're talking about general damages, the emotional distress, the idea that there will or could be something in the future. And that's why the medical monitoring affects the general damages. I mean, look at what, and I could go even further. Judge, the jury verdict form addressed past and future. And the Supreme Court yesterday in Valley Health System versus Murray pointed out that the verdict form there for grief and sorrow explicitly commingled, quote, past and future grief and sorrow. So here, where the jury verdict form explicitly tells the jury that they are to or can award past and future damages, is the end of the analysis in this case. It didn't say it in Bon Jovi versus Sullivan. I gotta say, my side in Bon Jovi versus Sullivan was really grasping at straws to bring up the mention of future in a jury instruction. That was not enough in Bon Jovi versus Sullivan, but here you have the evidence and the verdict form. I don't think you need to go further than the verdict form. I don't. And
No, I
I
understand
think,
your position. I get that. I get that.
all right.
I do. I understand.
Counsel says Justice Hardesty did not. Justice Hardesty's test is a bright line. Woo! Not applied to this case. Their idea of punitives is like, well, you know, a judge should reduce the offset. How? Why? They don't say. In Justice Hardesty's case, in J.E. Johns, it was a bright line. It was a treble damages statute that automatically applied. I cannot believe counsel is bad mouthing Texas cases, because that's where Justice Hardesty got this whole idea. And the Texas case that first said you've got to make a prima facie case by showing the settlement agreement, Justice Hardesty cited. He could have cited the earlier case, which said, yes, you can reduce an offset for punitive damages. But that earlier case had a settlement agreement.
The only reason, you know, I kind of get that, and I think sometimes, here's an example that I think of. And because you're not saying that just because that specific case is cited, we should adopt the holding of that case on all issues.
I'm going further than, well, not quite that far, but I'm saying that Justice Hardesty was aware of the case.
I understand, and that's the difference.
Further than the earlier cases that said you give an offset, and said what the court needs to consider for there to be a prima facie case of a reduced offset is the settlement agreement.
And the only reason I bring that up, I remember in Williams, he was saying, well, I don't want to have a bright line as it relates to nurses opining on medical causation. Then he makes a reference to a Tennessee case for that bright line. My point is this, and I looked at that Tennessee case, and the Tennessee case was a nurse practitioner, and under Tennessee law, they can't diagnose. And so he didn't make the distinction between a RN and a nurse practitioner. And that's kind of the way I look at it. And just as a side note, I'll just tell you this, I look at medical causation as a statutory issue. No one's ever said that, right?
Oh, you said that before.
Right, and it really makes perfect sense. But circling back, and that's why I kind of brought it up, because I just wanted to make sure, because I mean, I'll take a look at the Texas case.
Yeah.
But sometimes we cite cases for, you know where I'm going, right?
I do this for a living.
Yeah.
I get that a case isn't necessarily controlling,
Right,
but I mean. he
and you
did.
do this for a living. You do.
Yeah,
You do.
The
And I'll
Good
tell
one,
you
yeah.
this, I mean, I don't mind saying, I enjoy the bigger cases, I do. I just do, like these
Well,
cases, when you
yeah.
guys come in, I just enjoy it.
Well, and you do enjoy the dialogue.
Oh,
and
yeah.
We're lucky in cases like this, we get to do things. I did promise Will we'd be out of here by Tuesday, though, so.
Well, we have to be out of here by Tuesday because this afternoon I have Mr. Feldman and Mr. Brinsley coming in finalizing pre-instructions and all sorts of wonderful things that I have to kind of bring them back on point
Yeah.
on.
Well, as long as we're off on the Williams versus District Court tangent. I really, I backed off a little during oral argument on Hambrick. But that was an evidentiary issue.
Oh, absolutely.
You can tell from the expert cases that Justice Hardesty believed district judges should have a little more discretion and fluidity than the federal Daubert standard.
Absolutely. And our statute's different, so.
Right, and
yeah,
still say that still say you're a gatekeeper.
absolutely.
Right, I don't think he's calling for that kind of discretion here. To say that you can do anything you want on an offset. He had a clear case in front of him in that case. And he hated when I would individualize Nevada Supreme Court opinions to the author. So it was the Supreme Court addressing the issue, but
I
that was
understand. I understand why you do it, because for example, when I read Countrywide, I think of Justice Peregrine.
yeah,
Right? I mean, that's just how we do it. And I remember some of the Maupin decisions. I mean, I just think about it that way.
now
because-
I mean, as long as we're not on the record, I try to forget the Maupin decision. So, so you can't say that this is the unique
This is being
exposure.
televised, okay? People are.
I was fully aware of the fact we were on the record. So, he tries to make the argument that this is some unique exposure here. No, a unique crystallized solid exposure is when you have a treble damages statute. They don't even
Or a
try.
double damages statute. is it?
Right.
Yeah.
Oh, right. But here you don't have anything even solid. They don't even make a prima facie case. So I don't, and he's saying that the court that the jury actually adjudicated the ratio. No. They adjudicated a ratio having to do with the case in front of them with real water. Right? They adjudicated a ratio with me of 0. You can't say that the real water adjudication would apply to someone who settled. And I would go so far as to say, if you were going to address that, I would bring up things like, well, he went against real water because the punitive damage case against real water was better than it was against the ones he settled with. So you can't just draw numbers from somewhere else and apply them here. I could go on, but I think we all know that. So thank you, Your Honor.
Thank you.
Yeah, Judge, one minor point, Mr. Polsenberg, I think he misspoke, or maybe I misheard him. I thought he just said he's not seeking a credit for the $250,000 that was paid by Real Water to Haley and the $250,000 paid by Real Water for Gallagher. In his brief, he asked for.
I did not say that, and I certainly didn't mention numbers because I know that Mr. Kemp would be mad if I said any numbers.
Yeah, and I think
Those
the
are
only,
offers of judgment.
yeah, but I think the only reason he's bringing it up, he wanted to make sure we had a clear record.
Yeah, you want to write that?
And I did not
Oh,
say what he just said like
Yeah.
that.
Well, he said that Milwaukee's not arguing for an offset with regards to Real Water. That's what he said. So maybe I misunderstood him. But I mean, I think that $500,000 in payments, Your Honor, that's the best example we have. So he says that that it should be all allocated to compensatory when we know for a fact that the jury adjudicated the Real Water liability on an 89 to 11% ratio because the trial went on against the other 5 plaintiffs in Real Water. So you've got to apply the actual adjudication to the Real Water portion of the offset. I mean, there's no way around that. There's no credible argument that that's not the ratio 89 to 11, because that's what the jury actually determined the ratio for Real Water was for compensatory to punitive. So, applying that ratio would be, whatever it is, it'd be like 25,000 each would be the offset for those two cases. But the same ratio we contend should be applied for the UNFW settlement, because like I said before, UNFW is the distributor of real water. And, you know, if Mr. Polsenberg want to argue it should be 3-to-1, you know, I don't think I'd yell and scream about that too much, but you got to have some kind of ratio. Otherwise, you're penalizing, you're taking money away from the plaintiff that should be allocated to a unique exposure of the defendant. And again, the unique exposure of the defendant would be, in the UNFW's case, punitive damages, because Milwaukee did not get hit for punitive damages. So I think that example with real water's 500,000 makes crystal clear what we're trying to argue.
And
okay.
lastly, I'm gonna let you have the final word, but I just want to make sure J.E. Johns, for example, is cited in the defense reply, right, at page 14,
Yeah, we cited in our opposition.
opposition.
And we cited Mobile Oil as well in our reply.
Yes, and that's page, because I'm just tabbing this, and hopefully my law clerk's listening, and she does. So we can make sure we know which cases we need to review.
Flipping over to the interest, Mr. Polsenberg said there was evidence from Mr. Parker's argument that people were buying tests in the future. Well, that's medical monitoring. Okay, that was an item that we didn't take prejudgment interest on. Thank you.
Okay, so
Mr. Parker, before we give Mr. Kemp the last word, I know you were trying.
I object to all the sir rebuttal.
Well, I don't know, you know, one thing about it, I don't think it really matters in this respect, because I tend to listen to everyone, and ultimately you're gonna get the last word. Rightfully so, right?
Right.
Because if I held it hard and fast as many times, Mr. Polsenberg, you wouldn't be asserting your position. Because I always give you a chance to do that, because I want to listen to you, I really do.
You know, in my day job, they make me shut up after 15 minutes.
I won't do that.
Thank you.
I won't. Any comment? I know you wanted to make a comment, Mr. Park, and I appreciate the patience.
No problem, Your Honor. I enjoy listening to Dan explain cases that I've tried. The Bon Jovi Sullivan case, Your Honor, that Mr. Polsenberg was speaking of. The reason why that was 1-to-1 is because Don Campbell was a very good lawyer. Actually asked the jury to consider his attorney's fees and costs when he received a lot less than he anticipated receiving on the compensatory side. So he received $250,000 in compensatory damages for the defamation claim, and expecting to receive a lot more, he decided to do something that I objected to during his closing arguments. He informed the jury of his attorney's fees and costs. And as a result, it sort of backfired on him, because after trial, post-trial motions, and I've raised this to Judge Perigary during the trial, I said, if he asks for attorney's fees and costs or puts that in front of the jury, he should not be allowed to ask for it again post-trial. And Judge Perigary agreed. So that's the reason why I believe the jury gave Dr. Sullivan $250,000 in punitives, because that's roughly what Mr. Campbell said during his closing arguments. That's my recollection, having tried that case. So I don't agree with Mr. Polsenberg in terms of why that 1-to-1 is set some precedence in what's acceptable. That was not the point of that case in terms of how it was tried and presented to the jury, and then post-trial motion, he was foreclosed from asking for it again. And so I wanted to point that out, having had the pleasure of trying that case against Don Campbell. And so, Your Honor, you've talked about cases where there's a 2-to-1. We've talked about treble damages in certain cases. And I think based upon the briefing and certainly the oral argument put forth by Mr. Kemp, it is not improper to award 10 times in this case. I mean, the jury verdict on the punitives, I'm not going to address the offset, Your Honor, but the jury's verdict in this case is actually less than 10 times the compensatory awarded. And certainly I think Mr. Kemp has indicated the cases that support the court allowing this punitive damage amount, Your Honor. That's all I wanted to add.
Thank you. And the only reason, one of the primary reasons I wanted to hear from Mr. Park, and I might say is he tried the Bon Jovi case. Mr. Polsenberg did the appeal. So I want to
I
hear,
did.
yeah, I want to hear from both of you fine gentlemen. That's all.
And I'm glad that Teddy brought up, I thought that was the good argument on the punitive damages in Bon Jovi versus Sullivan, that Don had argued to take into account my attorney's fees when you award punitive damages. I thought that was improper, but that's not what they're arguing here. What they're arguing here are a couple of other different aspects. So in State Farm versus Campbell, that as long as we're talking about ratios, remember one of the justices in State Farm versus Campbell talked about a single digit limit under due process.
And that was the State Farm case out of Utah, right? You're talking about.
That's right. It's 538 US 408, but at page 425, note that the court was talking about when compensatory damages award is substantial, then a lesser ratio, perhaps only equal to compensatory damages, can reach the outermost limit of the due process guarantee. So, you know, there are a number of cases throughout the country and Nevada with a 1-to-1 ratio. So let's not all think that it's the Teddy Parker Don Campbell show. This is not an outlier. For them to come in and argue a 9-to-1 ratio, which some of the US Supreme Court justices think is too high, is sufficient to just make up what an allocation would be here. Yeah, there are. That's fine. I'll keep going. So they talk about penalizing. Okay, they say giving a full offset would penalize. Look, really, do we have to go all the way back to the 70s when these statutes were passed? Remember, when we came up with the Nevada pretty unique idea of comparative negligence, the jury allocates only among, now I realize they don't do this necessarily in products liability cases except for subrogation, but when you allocate damages under the comparative negligence statute, NRS 41.141, you at the end of the session in 1979, somebody came up with the idea the jury should only consider the parties remaining at trial, and that passed, and we've had it ever since. It's fairly unique, but how then do you figure out the allocation to a settling defendant if you can't put the settling defendant on the verdict form? Well, under chapter 41 and under chapter 17, 245, you then give the remaining defendants an offset for the settlement by the settling defendants who were not at trial. And that's how we do the best job of approximating an equitable distribution among all defendants present and settling. Counsel comes in and says that we should come up with some way that gets rid of 90% of that offset. That offset is part of the delicate balance that makes our comparative negligence and contribution issues work. Their idea totally undermines the statutory scheme. And I think it's inappropriate per se that it fulfills the policies of these statutes and penalizes parties. They have also, and I forget which one, these fine gentlemen talked about medical monitoring. I am not talking about special damages for medical monitoring. I am talking about the fact that medical monitoring reflects the idea that there is future element in the general damages. So when Teddy talks about they're looking at down the barrel of a gun. For having to buy future tests, it's not the fact that someone has to pay for the future tests. It's that there's going to be future treatment, future uncertainty, future mental pain and suffering. And that makes that part of the future damages. And, you know, I'm gonna end with what I tried to end with last time. It's in the verdict form. Are we actually, and I've set out all the stuff in the reply brief from the doctors and from the plaintiffs. Do we really think the Supreme Court's going to say, oh, when in Murray, they said, look, the verdict form commingled it, past and future, explicitly, which is the word the Supreme Court used, where they've explicitly put this in their proposed verdict form. I think that makes it clear that there's a component of future damages, so they should get no prejudgment interest on those elements.
And I just have one last comment, and you brought up, and I guess I should say question, you brought up the State Farm case again, and understand this, I haven't read that in a while, but it's my recollection when they talked about a limit on the assessment of punitive damages. And it couldn't offend the notions of due process, and there had to be some sort of limit, and they suggested potentially 10-1. And I do understand you said, look, Judge, but in maybe significant compensatory damage recoveries, it should be less than that. My question is this: how do I determine what is a significant recovery?
Right.
And the reason why I thought about that is this, because for example, if you had a compensatory damage recovery of say $5 billion, then under those circumstances, and I think everybody would agree that's a fairly significant compensatory damage. 5 billion. I just use that as an example because I think that everyone would agree that's significant. That's a little bit different than say a $5 million. And so I'm trying to figure out, what do I look at in that regard? Because is that a scenario where it's 1-to-1, or is it a scenario where, look, that's not necessarily a significant, you sure I'm going on that? Because
I do, and here, let me give you the short answer first. You don't in this case.
okay,
Because you're not examining the excessiveness of punitive damages, because there wasn't we're not reviewing a punitive damage award. We're looking at this funky math that they've come up with for you to allocate, and there isn't any real allocation here. But my point on State Farm, one justice said single digit, so I always say 9-to-1. So they are saying in larger, but you know, large I think is a function of the case.
I know where I'm going.
Not
Yeah.
necessarily to say 5 million isn't large. I mean, I don't know what you make, Judge, but 5 million is a lot of money to me.
Yeah,
Did you
but I
say 5 million or 5 billion? I thought you said.
He said billion.
no, I said 5
He
million.
said
No, I used two examples.
two examples.
5 billion would be,
Right.
I think everyone
But
would probably agree that's a pretty excessive verdict, right? Whereas 5 million, I don't know, not in this litigation age, right? And so I was trying to, so I guess I was kind of focusing on this. Okay, we're not talking about scenarios where you might have fairly significant verdicts, maybe in a toxic tort case involving spills and those types of things. I mean, I don't know, but the plaintiff's compensatory damages awards in this case, and you're saying, look, Judge, where there's a significant compensatory damage component, should be a lower number as far as the ratio is concerned. And then just as important too, what parameters do I follow to make a determination that the compensatory damage verdicts in this case would be significant? And all I'm trying to say, look at it from this perspective, how do I anchor? that.
Judge, I think.
Hey.
And here's.
I'm still in my double reverse server rebuttal.
Yeah,
argument.
you are, but I understand this. I'm asking questions and I'm gonna give Mr. Kemp a opportunity to
You
answer
want
that.
him to go first?
No, you can go, no, you can go for.
Go ahead, Roll. You.
No, you know what?
Judge, I was just gonna say that, we've been talking, he's been talking about the 4-to-1 ratio from BMW versus Gore. Completely forgetting that, the other Supreme Court case says single digit. And also completely forgetting that in Nevada, our Supreme Court has not won the 2 decisions approving a 12-to-1 ratio in insurance bad faith context. So I mean, we're only talking 89.11%. I think that's 9.85. We're so far under the 12 or the 10 even. I don't even know why we're talking about this, because this is not a motion to reduce the punitive damages award. If Real Water didn't even file that.
No, I understand.
We're just trying to look at the allocation.
That's what I'm looking at.
I
that's my
agree
point.
that this is not the issue in front of you, and that's why I gave the short answer first. The reason I raised all of these, I mentioned Gore. The reason I raised all of these is so when they come up here and say 3 times compensatory is automatic, it isn't automatic. It isn't automatic either for juries or for reviewing courts. So there is no automatic ratio for you to consider. And that's why I'm saying you shouldn't consider this at all, because it is just too nebulous for a court to make up something here. He says it's a bright line test under Justice Hardisty's opinion and J.E. Johns. It's far from a bright line. I don't think the record will reflect the way I went, woo, when I said it earlier. But woo, there is no clear-cut direction for a court to even go here if they wanted to go here. That's why I think all courts should reject this concept. The closest we have is one that says for them to make a prima facie case, they have to show the allocation of the settlement agreement. So this is the kind of case that would be fun to pull hair out over, but I don't think it's presented. Thank you.
Thank you. Where do we go from here?
I think that's it.
That's it? Are you sure? I'm surprised.
Yeah, let's see. Yeah, I told everybody to be out by 10, so I think we're done.
Oh, we're done. And I just want to make sure we have, as far as, and I assume Sarah's probably on the line listening, but we have the J.E. Johns case and the State Farm case. What's the site for that? I just want to take a look at it.
It is, I only have the US site.
No, that's fine.
It's 538 US 408, and I pin cited that quote about 1-to-1 was at 425. That's from 2003, which might make it easier to find.
Oh, yeah, we'll find it.
And the mobile oil case versus commodity trader.
That cited J. Johns, cites in J. Johns.
Right.
Okay,
And we cited in our brief as well.
I got you. I just want to make sure.
Thank you, Your Honor.
Thank you.